Welcome to EMBARGOED, intelligent talk about sanctions, export controls, and all things international trade. I'm your host, Tim O'Toole, and with me today are two great guests so that we can talk about the ITAR year in review. And my first guest is Johanna Reeves, who is a longtime ITAR and export controls lawyer in Washington, D.C., and a good friend and colleague with ECTI. So welcome, Johanna.
Hi, Tim. Hi, Melissa. Thanks for having me.
Oh, it's great to have you here. And our other guest is Melissa Burgess, who is a regular of the show now on export controls issues and also a lawyer who works with me at Miller & Chevalier. Welcome back, Melissa.
Thank you, Tim. Glad to be back.
So great to be talking about the ITAR and 2024, which maybe it wasn't a big year, but it was an interesting year. And so why don't we walk through a few of the potential issues that our listeners should be aware of in terms of what changed in terms of the ITAR in 2024. And why don't we just start with some little changes, maybe, some changes to 126.1 countries, some additions, maybe some guidance for universities. Johanna, why don't you talk a little bit about some of those little changes, and Melissa, chime in wherever.
Sure.
Whatever you like.
So we saw Nicaragua being added to the list of 126.1 countries, and I don't think it was totally unexpected given the internal developments, the alignment with Russia, and the restriction, of course, like a lot of the 126.1 countries, it's case by case. The important thing, I think, is because this gets a little bit confusing for folks, but the references to exporting and importing, the restrictions also apply to the brokering activities as well. So that's one thing that people should keep in mind. It's a pretty sweeping restriction. The only exception that I saw is for non-lethal military equipment that's intended solely for humanitarian assistance. So there's going to be a pretty steep hill there for the applicant to show the need. So I mean, that's it for Nicaragua, unless Melissa has anything to add on that one. Pretty straightforward.
Not really. but that is the trick with any 126.1 country, that essentially the need for a talking license, as we sometimes refer to it. It's not just that it's a steep hill once you have something signed on a dotted line. It's a steep hill long before that.
Yeah, the marketing requirement, right? I mean, any kind of marketing activity is going to be captured under those restrictions as well, at least to the extent of needing a license beforehand.
Yeah, and I mean, I'm not sure how much activity there was in this area in Nicaragua before the addition of Nicaragua to the 126.1 list, but I'm guessing that whatever activity was there is probably pretty much gone now.
Yeah, right, yep. Exactly. Yep.
Well, why don't we also talk about the State Department came out with some guidance. I think they called it commendations and recommendations for universities back, I think, in April or so of this year. And I thought that was pretty interesting. So, Johanna, do you want to talk a little bit about that, and maybe we'll chime in as needed? Because I know you and I taught the ECTI University Export Controls together at Ohio State last year, and so it's definitely a topic of interest.
I think that this goes along the lines of just in general, the increased interest and outreach, for lack of a better word, that the agencies, both State Department and also Commerce, have had with the university sector and the research sector. The commendations and recommendations, I think it's a great resource for universities, but also for people outside of universities, just to get a feel for State Department's view on some of the actions that an entity can take to move towards compliance and work towards continued compliance. I also thought it was interesting that the State Department specifically identified I think it was in the commendations section, the membership with AUKUS. And I think From what I've seen, and I don't have a lot of experience with AUKUS, but I think they've done a considerable effort to increase awareness among universities. And we've seen this growth in the presence of universities, not just with compliance programs, like the ECTI type courses, but also with industry groups, specifically DTAG. We've seen increased university presence in DTAG as well. So I think it goes along those same lines, and I think it's a really good reference and a little bit unique, right? Because they have not just the recommendations but also the commendations as well.
Yeah, in reading through it, I mean, one, the fact that they essentially make it a best practice to join this organization, AUKUS, was interesting. I mean, good. I mean, good for the organization. I think it'd be good for the people who join it. I mean, we've had a little bit of exposure to that through the work with our university training, but it was, I think, a little bit unusual to have the government kind of recommending joining a particular group as part of the best practices. I also thought that. What the other thing that was interesting to me, and this isn't totally university specific, but it is something that I think we see in our practices a lot, is this recommendation or accommodation for universities that get involved early on in the contracting process and having compliance folks early on in the contracting process. For me, like, that is one of the biggest challenges of our job, is that we have this kind of unique little practice that does affect, research projects at universities, but also affects all sorts of other kind of investments and other projects. And we often get contacted at the very end when the deal is close to done and everybody just wants us to sign off. And a lot of the times it's set up completely in a way that you never would have recommended it to be set up if you had kind of gotten involved early. And so I thought that was both a great tip for universities, which, when we were in Columbus, I think we had a lot of questions about that, like, how do we get involved in the contracting process early? So I thought that was, very interesting as well. And then I also thought that basically the way that the State Department kind of walked through each of these recommendations in line with, closely tailoring it to the more general guidance on setting up compliance programs was good, because it helps universities kind of know how do we take these more general recommendations and tailor them to the university setting. So I thought it was very helpful, and it's also helpfully short. I mean, it was 8 pages in big font.
Yeah, exactly. And I think it's a little bit of a looking outward, not just for universities, but just in general. When you have, especially with larger companies, it's kind of a two-sided coin. On the one hand, you have the need for awareness, not just of compliance, right, but also of the existence of the compliance people who are there not just to put a stop to things, although, given the circumstances that could be important, but also to help educate and bring a transaction into compliance. So it's I think an important outreach aspect internally. So you have the outreach of the government, but you also have outreach within organizations and business entities, especially the bigger ones, to make people aware, look, we exist and this is our function, which serves the whole company because of the compliance, the different touch points of compliance, and the detrimental effects that enforcement can have if compliance is not obtained. So I think that that's a really important, again, not just for the universities, but also for the larger companies. But also validation goes along with that as well, right? A message from the top that, yes, this compliance program and the people who help implement it matter, and they that can be shown with funding and increased notices and messages about the importance and the role. So I think that's not just specific to universities, but it definitely spans across the export spectrum.
And Melissa, any further thoughts? I know we work together for some universities, and so interested to hear some of your thoughts on this.
Well, one, I think, just as both of you have pointed out, this is a useful document to read for anyone who does export compliance, anyone who has any type of research function, no matter how commercial, because even if you're reading words about university references to university presidents and the general counsel's office, overlay your own structure on that and think, look, DDTC is saying this has to be, clear reporting lines, clear authority lines going straight up to a university president through a general counsel's office. We have a CEO instead, but this is what DDTC expects from us. And many of the other recommendations, again, contracting, all of the rest, they really do apply to any function. One recommendation that I do think is very important to highlight for anyone that receives foreign funding, and has a research function that may be affected by, linked with that, is the recommendation to vet that funding and vet that funding for any export control considerations they may be. Is it really just dollars with no strings attached, or is this dollars for a very specific program with very specific outcomes, and maybe those outcomes will be released from export controls, less likely in an ITAR context than under the export administration regulations, but not impossible. But having that vetting function and analysis early on is important for export controls, and it's really important for any company or any universities that are receiving other U.S. government funding. And of course, Department of Education reporting requirements, DoD restrictions. So there's a lot of things that one little step can accomplish or facilitate.
Yeah, and it's a good reminder of the crossover between government contracts and export controls in that, when you have this funding, but if you're also getting U.S. funding, you can create all sorts of other restrictions on your project that wouldn't otherwise be there once the U.S. funding comes, and the foreign funding also comes with strings attached quite often that can create particular issues. We've seen it at times with respect to Huawei funds a lot of research around the world, and because of their status, that can create all sorts of different issues with respect to potential research that's being done at universities, particularly U.S. universities that have branches overseas, which a lot of U.S. universities do now. So, great. Very interesting stuff. I mean, the one other thing to Johanna's point earlier that I also found very interesting was this idea that the compliance group should actually work to facilitate the business. There was one recommendation that essentially said you should try and work together with the business and not get in their way, which I thought was a very sophisticated insight from regulators, because often what we see with regulators is, compliance's job is to say no, 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 no. And what winds up happening in that set of circumstances, and this isn't unique to universities, is that the business people don't want to talk to compliance because they see them as a roadblock. And so making compliance kind of part of the process where the business actually thinks, or the university professors think, that the compliance people are working with you to get to an answer that is safe, and if possible to get to a safe yes, is really important in my experience, because otherwise people try to circumvent compliance, and that's obviously not what you want to do. But I haven't seen regulators kind of address that issue directly, and it was, I thought, quite interesting.
Yeah, I think that's a good positive development for a regulator to recognize that, because it's a reality. And to your point, Tim, about people trying to avoid bringing in compliance people, that's the worst case scenario, right? Because when there is that kind of shielding, then that's a recipe for violations to occur. And then cleaning up a violation afterwards is a lot more difficult than trying to work towards a yes in that way. And I think also we've seen increased enforcement too, where cases have involved portions of the company or employees either ignoring, purposefully circumventing compliance efforts. So it is something that it needs to be recognized by the regulator, the importance of marrying, I don't know, marrying if it's really the right word, but working together so that you can have business growth and development that's in compliance.
Yep. I think that's a great point. So why don't we leave the kind of lightning discussions there and go to a few of the deeper dives where we'll talk a little bit more about some of the actual changes to the ITAR. So I guess the change to 126.1 was a change to the ITAR, but I think, it was so specific to Nicaragua. What I'd like to just kind of throw out there first is the expansion of 120.54, and that is the definition of exports. And the way that definition is set up, there are, certain items that are exports, but then there's a list of items that are not exports, reexports, retransfers. And basically, there were a couple of changes to 120.54 that carved out from activities that would otherwise be exports, not turned them into, by definition, not exports. You want to talk about a couple of those? What I'm thinking of is, on the one hand, there was this military personnel where you take items on deployment, and if you cross international lines or even they're, within the same country, it could be a transfer. And then also the carve out for items that come into the United States don't get fundamentally changed and then leave. U.S. export laws and the ITAR in that circumstance would normally apply, and there was a carve out.
I think that I'll take the second one first because I saw a lot of confusion of the scope of ITAR control with foreign parties. There was I think in some circles, a belief, misunderstanding that anything that came out of the U.S., if it came under an ITAR license, then it was automatically forever and ever subject to ITAR. And the presumption was that even if it was U.S. origin, hey, we make this product and we sent it into the U.S., now it's coming back to us. How can it be ITAR controlled? And the answer was, actually, it's not. As long as there weren't any changes or modifications, enhancement, that kind of thing. I had a situation, it's over on the BIS side as well, and it's an important carve out. I don't even know if you can really say carve out per se. But I had a client where they had imported foreign origin product into an FTZ, and then they ended up exporting it to a customer because they couldn't bring it into the U.S. Long story, but the customer overseas who received the product was asking for a re-export. How do I get a re-export authorization? How do I get a re-export authorization? And it took us a while to get him to understand you don't need a re-export authorization because it's not subject to the U.S. export controls. No changes were made. And I think part of the confusion, of course, the use of FTZs often is to modify something, but since that didn't happen, there were no controls that attached to us. I think that it's good news for foreign parties, but it's not new either. I think it just codifies the pre-existing policy anyway.
Yeah, I mean, there was a lot of confusion on this because by definition, items would acquire U.S. export control reach if they were within the United States. And certainly under the EAR, that's true. I think it was true under the ITAR before this complete carve out. And so I think that's where a lot of the confusion came, because I know that when, we would go out to ECTI trainings, I would get a lot of questions on this, and it became, you had to, until they've, and maybe clarified is a better were, but until they clarified the rules, you had to find some sort of exemption that would essentially stop U.S. export controls from applying, where by definition, if something was in the United States, it could acquire U.S. export controls reach. And now it's clear that if you don't have any modifications while you're in the United States, that you and it leaves the United States again, then you don't have to get re-export authorization. And I think even worse would be retransfer authorization, because a lot of these issues come up because of the transfer restriction, where if you're going to even just transfer it within the same country and it's not the U.S., this idea that the ITAR applies is one of the reasons that so many of our clients say, we want it ITAR free, because it's like I can't even move it from one location down the street to another without going back to the State Department.
Right. Yep.
Yeah, but the important thing for the importer exporter to keep in mind is doesn't mean you don't need a license for that trip to the U.S. Don't forget that one.
Right.
But once
out of the U.S.
doesn't mean ITAR forever.
Well, and that is actually
so you can bring it in for the demo. Once it leaves, then you'll be good.
And that is really important too, because you have to know that before you send it in. Because if you don't actually, follow the rules in sending it into the U.S., then you'll likely need an entirely new authorization to get it out of the U.S. Because there is that exemption that allows quite often for, the import into the U.S. of items that were lawfully exported before. If it's going to be for repair, it's possible that you could take advantage of that. But if you don't do it beforehand, you're not going to be able to do it on the way out, because you'll have already missed your opportunity.
Yeah, I think that's one area where the government could really do a lot of good, I think, in terms of clarifying temporary imports into the U.S. There's pretty significant distinctions between the ITAR processes and then EAR processes, and then of course you got to bring in certain circumstances another agency, ATF. Can't have enough agencies, but because of the differences, it's rife with confusion, and I think that, I don't know, maybe somehow leveling it off so that it's more consistent, or more clarification is not a bad thing, I don't think, in this area.
Yeah, and it's also just kind of another reminder, kind of think about these things early, because again, you need to be thinking, okay, if I'm going to send something back into the U.S. and then have it come back out, I need to think about, like, how do I get this licensed beforehand? How do I make sure that it properly gets into the U.S.? If it's possible to get it out of the U.S. without a separate authorization, can I do that by following the rules, or do I need to figure out the authorization now, both for the import and later for the export? And whether it's the ITAR or the AR, and the rules are quite different, you need to figure that out early, instead of kind of waiting until you're trying to get the item out of the U.S., because if you're already at that stage, it might be too late, and you're going to have to do something that you otherwise wouldn't have had to.
Yeah, the freight forwarder and customs probably not going to be a good source of information on that.
Usually the last place you want to ask. All right, well, why don't we talk about the other change to 120.54, and that's the one that deals with these kind of training missions where you take defense articles and you're in a military force and you're training, and you either transfer them within the country or you cross international lines as part of the training mission. And prior to this carve-out, I think that was one where, again, my understanding is that people may not have been seeking these authorizations all the time, and there might have been a lot of misunderstandings, so this might essentially be codifying what was already being done. But it's good that there's clarity now. Thoughts on this?
I think I actually have a client that from time to time has to deal with this challenge, where maybe the contract has changed, or the what starts off as being work in one country, now they must go to another country, and it's talk about a confusing area. Hey, you don't relinquish control, you maintain possession of the articles, so what do we have to do? The license only mentions one country, now what do we have to do? So I think that there's hopefully this revision or addition to the regulation will help in those circumstances. But I think it's some of the general rules, though, are still in place, and I think not much has changed there. Whereas, possession can't change. Let's see what else. And of course, if in doubt, maybe go in for the license. But oftentimes there's not that much leeway either in terms of time.
Yeah.
This stuff happens really quickly.
Yeah, that is one of the good things about this development.
Yeah.
But I haven't seen actual use of this edition yet. But
Yeah.
it's still early, right?
Yeah. I think the most dangerous thing about it is reading it too broadly.
Yeah.
The regs, the narrative does explain again and again, this doesn't apply to contractors. This is really just about those armed forces. So if you're supporting them in any way, don't overread this to include yourself.
Yeah, and I think that knowing, just like with anything else, knowing at the beginning, going in early, figuring out what is happening and who's involved, and as far down the line as possible. But it may be, again, one of those instances where does it really get utilized? I guess we'll see.
Yeah, and I think that, to Melissa's point, the fact that it only applies to the military and not to the contractors and to other participants may mean that it doesn't get applied as often as you would think, because you can't get everybody done, so you have to go and get a license anyway beforehand. So, it comes back to our original point, which is figure this stuff out early.
Yeah.
All the participants, as you said, Johanna, make sure that you've got an understanding of who's involved and what authorizations are going to be necessary, because if you don't figure this stuff out early, then you are potentially going to be in some real trouble.
Yeah. The old buy and for exemption, right?
Exactly. So why don't we from there, unless anybody has anything else to say about 120.54 and the new changes, why don't we talk about AUKUS, so Australia, the UK, and the US. I mean, there was this, at least, mythology that at the beginning of the Biden administration, in this effort to kind of build relationships with allies, that the State Department spoke with representatives from Australia and the UK and asked what they wanted to see changed in the ITAR, and they wanted, I think, to make it easier to move stuff around within their own countries without a license. And lo and behold, it looks like there were some changes that at least made that more likely, or at least seems to make it a little bit easier. Johanna, do you want to talk a little bit about some of the AUKUS changes?
Sure. Where to begin? So one thing that will be interesting is to see if there are any developments that occur in 2025. I don't know if comments are still going into State Department regarding the new rules, but I will be interested to see if anything changes. I did one of the interesting things, I don't know if you all saw, but in terms of the FAQs on State Department's website, I don't know if it's the most in any given topic, but I think it's approaching 60 now.
It's a
FAQs.
lot.
Yeah, most of them were released, I think in August. There was some recent developments. I'll talk about one in a second because I thought it was kind of interesting, and I don't know if there's a disconnect yet, but we'll see on that. One of the things that really strikes me about AUKUS is that it's still limited, right?
Mm-hmm.
It's not as broad as the I don't know if you want to call it the companion changes over on the commerce side, but there's that long list of excluded technologies. Also, in terms of the expedited processing, that has interesting language peppered throughout that section, not the least of which is the exceptional circumstances, and also, what is it, to the extent practicable. I don't know how that's
Yes.
going to translate. And that, of course, the expedited processing can only be used. I thought this was interesting. If the if the export doesn't qualify for the exemption, then you can use the expedited processing route. But it's not a situation where someone can say, I don't really feel like bothering with the exemption in 126.7. I'll just go in and since I can get my license in 30 to 45 days, then I'll just use the expedited processing. But that's not going to work. Because the government has said you can't use that pathway. You have to use the exemption.
Yeah.
Right? I mean,
Yeah, no, I mean, and that it's interesting that they did that because there's a lot of times where it's gray.
right,
And so what you'll say is, I think you could use the exemption, but if you want to be safe, you go in and you get the license and you got this expedited processing, so it's only an extra 30 to 45 days, and then once you're done with that, you're safe, right?
right,
We know that you're authorized as opposed to we think that you're authorized, or we, think that more likely than not that you're authorized. And
right.
so it does, we'll have to see how, the State Department deals with that as a licensing matter, do they apply that to obvious cases where the exemption applies only, which makes some sense because they're trying to limit the number of license applications since they do have a clock on, or do they apply it in situations where nobody could really tell beforehand that the exemption would definitely apply, but they tell you in refusing to expedite that their view is that the exemption applied, and so you're finding out as you're delaying everything, which would be a bad case scenario. I haven't had enough experience with this one yet to see which path they're going to take.
Yeah, the practicalities of the implementation. The other thing, of course, is the limitation to just those countries.
Yep,
you can't use the this. I think that will present itself more, perhaps, in maybe in agreements, but also in the brokering context as well. It's like if the brokering activity involves anyone else other than the UK or Australia, then you're not going to be able to avail yourself of the exemption.
But that's actually an important point that state made in the interim final rule is this is exports only. All those other things, or if congressional notification is required, this rule doesn't apply. So it's actually a very narrow, small bucket that is potentially eligible because, they read it as our mandate from Congress was exports only. So we don't have to apply this to everything else, and we're not going to. So again, limiting the utility, but maybe as people get used to this and they get used to it, maybe it could be expanded to some of those other areas.
Yeah.
At least for straightforward brokering or something. You'd think.
Right.
Right.
The other area, they back on December 2nd, they added an FAQ. I thought this was interesting about agreements and the incorporation or the relationship with 126.7. And there's new back in I think it was the very end of August when the regulations 124.8, right? These are the required clauses for MLAs and TAAs. It was revised to include a reference to 126.7. It used to only reference 618, I think it was. So now what the FAQ says is that agreements must contain the new language, which it makes sense. Theoretically, if you're going through and you're preparing an agreement, you're going to include the required clauses in the ITAR. You're going to go to the ITARs and include those clauses. But for anyone who works off of the guidelines, those guidelines have not been updated yet. So the old language in the regulations in 124 they don't reflect 126.7. So in the FAQ specifically, what caught my attention is that they even go to say if your agreement doesn't include the new language, the agreement holder must submit a minor amendment to update the subject clause. So that's kind of, I don't know how
Wow.
many people are doing that. Yeah. So
It's a great point, and it also
you heard it here
right?
first.
Well, and so this amendment that is designed to make things easier in those countries has now created a new
A bunch of
requirement that
work.
didn't otherwise
Right,
exist.
right,
They've got to
right.
go change these agreements, which can often be. I mean, we talk about this at ECTI when we're teaching it. That the changes to an agreement can be a huge pain
Hmm.
because you sometimes have these agreements with tens,
Yeah,
dozens of signatories, and so getting everybody to sign that thing for an amendment over the course of different
yeah.
countries and different it can be a real hassle.
Although they do specify it would be a minor amendment, but still, does that mean that anybody who doesn't do it is now in violation?
Right. And could you do it by general correspondence if it's a minor? I mean, I don't know.
Right. Well, and why I didn't see any kind of I haven't seen this called out. It was just in this little FAQ that was buried in the other 60 FAQs, and I noticed it just because like, oh, that's a recent FAQ. Let me see what that is.
Yeah.
Just trying to hide it in the holiday rush, I
Right.
think.
Right. But hopefully they'll update the guidelines soon. But
Yeah.
I mean, I think that this there was certainly a lot of attention on this. It was very fast. What was it, like 3 months that
Yeah.
Yeah.
the State Department rolled this out? I don't know if there's ever been any other amendments of this scope that have been put out so quickly, but I think that will be the interesting thing is how is this implemented because it was rolled out so fast. Is the practical implementation, is it going to live up to the expectations, not just of industry but also of the government as well?
Right. Right. I mean, I guess we'll see pretty soon because I assume this is going to start to be used more and more in
Yeah.
2025. But we'll see, this is kind of a test because it's our allies are coming in and saying, hey, we think the ITAR is too hard. Can you simplify it for us? And this was an attempt to do that. Whether it succeeds or not will determine probably whether or not other countries try and work this into their own treaties and try and simplify processes under the ITAR. Because if it is just as complicated as before, you just kind of move the complications from one place to another, then it's probably not going to be all that widely copied.
Yeah, I mean, I think it's an improvement from the pre-existing exemptions. Those I don't know how often those were used. Those are
Agreed.
still in place, so I guess someone has the choice. You
Yeah,
could,
I mean,
I prefer the old harder way. Maybe. I mean, it's
well, I taught exemptions in I think at the Phoenix conference that we did, and I will say that kind of it does create a little bit of complexity because you have kind of these overlapping exemptions for Australia and the UK that are now superfluous in many ways, although
yeah,
I think we spent a little bit of time trying to figure out kind of are there little areas where the old ones are still better and the new ones aren't. I mean, it's just it does create at some point because they did this so fast. I don't think they kind of made an attempt to weed out the old ones, but at some point I think on their to-do list ought to be how do we not have two kind of overlapping and maybe one superfluous exemption that was kind of got lost in the new shuffle where we rolled out this new one very quickly.
yeah, yeah. And I think the other challenge, and this is just sort of an ongoing theme with the way international trade is today and all of the challenges with countries of concern and how that landscape is changing. When you have a very limited exemption like this, where it only covers Australia and UK,
Yep.
nothing outside of that, the question may become how practical is it to use it? Because they're just the way international trade is. It may go beyond those countries in many circumstances.
Yeah, it's very hard to have a transaction of any great size that is just going to touch the US, the UK, and Australia.
Yeah.
So, agreed. Any other last thoughts on the rules that actually got through in 2024?
Well, it is an interim final rule, so I think it's going to bleed into our next conversation of what comes in 2025 as a final rule, and just how much will it change. I think the downside is obviously comment periods are limited, so people only had a couple months barely to work with the new rule before comments were due. So I'm sure there will be an ongoing discovery of gaps and gray areas where people will be wanting to continue to submit comments to DDTC and say, how about this one? How about this one? Not just, the defense treaty overlap. State tried to take care of a few of those things and say, like, FMS, this is completely separate. Don't talk to us about FMS. That's not us. And some other things. And there were some very interesting comments in there about, like, but DITSA and but this agency and this office. What are you going to do about them?
Right.
That's not what this rule is about. Thanks for listening.
Yeah. And I think AIA has been really active in this area too, so probably that will continue. Yep. Again, when it comes to that practical implementation, because it's really easy to see words on a paper, it's the practical implementation. Yep. That's when you really come up with the challenges and the realization that some of the wording may not be exactly clear.
Yep. But I think one other point to highlight about this, and this actually ties back to some of states' kind of smaller actions last year. They updated the U.S. person abroad guidance for U.S. persons who have to apply for export licenses in order to work for, a foreign company, foreign military, whatever it might be. But in the AUKUS rule and in the FAQs, they point out, well, you can be a U.S. person abroad authorized user under the AUKUS rules, but you're going to want to do your homework on that one, because if you do it under the new exemption, ITAR is going to apply. That is what you are signing up for when you say, I'm an individual authorized user, U.S. person abroad. But if you kept it under the U.S. person abroad authorization, ITAR might not apply to that end item that you're working on. So that is kind of an important distinction of, while AUKUS is trying to make things a little easier to work with, it's not an ITAR-free scenario. Right. So that, that may not be that many cases. That may actually turn out to be quite a few cases where you're suddenly having to deliberate, do I go the exemption route and I guarantee ITAR applies, or do I go and seek a license for this U.S. person abroad because we don't want ITAR to follow us?
Yeah, that's a good point, right? Exemptions do not mean that it's ITAR free.
Yeah. All right. Well, why don't we talk a little bit now about some of the proposed rules that are out there. And the first one is this, I think it's been coming for a long time. I think the State Department has been saying for maybe a decade that they were going to change the definition, or going to modify or modernize the definition of defense services. And in July of 2024, they proposed a rule that would essentially codify and add quite a bit of definition to the definition of defense services. You want to talk a little bit about that, Johanna?
Yeah. I haven't sat down and done a side-by-side comparison of the 2024 version versus, say, 2015 or 2013 or 2011, but it seems to be almost. I think it's expanding.
Yeah.
What is captured under defense services, as opposed to this great expectation that a lot of us had of finally it's going to be clarified and restricted, right? The scope brought down. That I don't think that's happening. When it's adding intelligence activities
that don't involve defense articles.
Right. Exactly. Yeah. That's a pretty interesting development. I'll be interested to see what the comments are on that. But anytime, I think it's interesting when you have two agencies that are working at the same time for largely the same area, right? Because we saw Commerce came out with its rules on what activities of U.S. persons are controlled, and this comes out with this concept of revising defense services. And it's such a I'm still going to use the word amorphous, because it really how a person, the activities that a U.S. person engages in, and it's important for national security and foreign policy when you think about how a U.S. person's involvement in a certain activity can undermine national security, it can undermine regional stability. But if there's not sufficient clarification, then the risk is that the ability of a U.S. person to engage in any activity is going to be severely constrained, and that could have a backlash on it. And I think that, especially with expanding it to include activities that don't even involve defense services, that's really going to have a pretty, I think, far-reaching impact when you're looking at national security. And I think also that was the impact of the military training and assistance as well. Because when you look at the roles of consultants, they're going to be significantly impacted by this.
Yeah, I mean, it was very broad, I thought, in terms of, new activities that don't involve defense articles that are now, caught within the scope of defense services. And they do try and do some carve-outs for specific types of activities, but however much they carve out, there's still this huge area where you're like, is this really a defense service?
Yeah, and I think anytime you have lack of clarity on that, and be careful what you wish for, right? I mean, do you want the clarity? But when there is that pause that's given, it can either result in just not engaging at all, which, depending on that, could be detrimental, or even quite possibly asking for forgiveness instead of permission. That could also be an impact as well.
Well, on that point, I mean, one of the things that happened in 2024, involved the Supreme Court's decision in Jarkesy, where the Supreme Court actually, struck down the SEC's enforcement mechanism by saying that if you want to impose a penalty, at least on the SEC side, you've got to follow the Seventh Amendment by essentially putting your case into federal court and having a jury decide what the proper penalty is. There's been a lot of discussion as to whether or not that principle, how far it would carry. I can tell you that the Jarkesy decision is written quite broadly, and so it's not clear to me that that even DDTC would be exempt in terms of imposing penalties. There's also been a lot of discussion about imposing penalties in the context of unclear rules. And so if I were representing somebody who was being charged with some violation of defense services, I certainly would be thinking about, okay, one, nobody can tell, at least to some extent, there might be easy cases, but there's certainly a lot of cases where it's not clear that they're covered by the defense services prohibition. And two, it kind of plays right into this idea that if you're going to do, enforcement of, particularly ones involving civil fines and civil penalties ought to be done in federal court pursuant to the terms of the Seventh Amendment as opposed to through an administrative proceeding. And again, Jarkesy is an SEC case, but the language from the Supreme Court is pretty broad. And so I do think that these broad rules like this have potential consequences in the penalty context, both from you have to have notice, and two, it kind of plays into what the Supreme Court said about Jarkesy is, if you want to impose penalties, go to court, because administrative penalties have these problems of lack of notice and lack of clarity as to what the standards are. So I do think coming in 2025, potentially to the State Department, but certainly to a lot of administrative agencies, are going to be these sorts of challenges, and the defense services prohibition kind of plays right into that.
Yeah, I think the landscape overall is shifting quite dramatically. It's also in the area of deference, right? There's no longer that deference to agencies, which I think is a good thing. because it was almost like the judiciary almost being held hostage, because if you have an agency decision, well, you must defer to it. But
See, I completely agree. The one thing, the thing about this, the Loper Bright decision that I find completely unexceptional, even though if you read the media coverage, they act like it's a huge, change in our system of government, and potentially it is. I mean, there certainly was a lot of just kind of reliance on Chevron deference, but it is a pretty long established principle that the courts get to say what the law is, and this idea from Chevron that an agency was able to better construe a statute than the courts because they've got some sort of expertise that whatever their expertise doesn't involve statutory construction always seemed kind of nuts to me. And so the idea that Loper Bright has kind of restored this balance where, the agencies can tell you what they think a statute means and a court can pay attention to it and defer to it in the sense that they think, okay, that required some technical expertise. I'm going to assume the agency is right about the technical expertise and then construe the statute makes complete sense. But the idea that the courts come in and say, agency, you can construe it however you want, and unless we can come in and say that that is demonstrably wrong, we're just going to let you have the final say, was always a rule that didn't make a ton of sense to me now. And I think that at first I thought it might not come up that much, but this decision involving OFAC, this Van Loon decision from the Fifth Circuit, in which the Fifth Circuit basically tossed out OFAC's definition of property in the context of it was a question about cryptocurrency and whether or not a certain type of cryptocurrency principle constituted property, and OFAC had said yes, and the court said, well, thank you very much, OFAC, but let's look at the statute and we'll decide what property means. That doesn't seem that exceptional to me that the courts get the final say on what property means, since they were construing a term from IEPA. And I think that, the agencies have gotten used to this idea that they'll just define what the law is without regard to the statute, and I think that they, as you said, Johanna, change is coming if that's really where you think that, you're going to be able to continue to tell people in guidance that the statute says X, but we've decided that Y is a better rule.
yeah. Now, with export controls, of course, we have the wonderful justification of national security.
Yeah.
And foreign policy. So foreign policy might be a little bit easier to define, maybe, but national security, that whatever
it's
that
what you
means,
want it to be.
Right.
Exactly. And I think that if we're moving now into like the enforcement discussion, if there's one thing that is becoming more and more prevalent is the overarching approach and treatment of countries that are adversaries, primarily Russia and China, and how that's going to factor into enforcement cases. It's always case by case, but I think that it's interesting because looking at the State Department versus Commerce Department, it's almost as though State Department it sort of continues on. It's a constant, right? I think last year we had three or four consent agreements, not any different from 2023, not really any different from 2022. So it just kind of goes on as it has been. The commerce side, we're seeing a lot of changes. There's the outward cooperation between agencies, the focus on technology. Now, maybe the justification as well, that focus has already been on the ITAR side, that in terms of the government's approach, it hasn't really changed. We see change on commerce because of the huge landscape of what is subject to those controls.
Yeah.
But I think also Axelrod has made significant changes in how the agency is enforcing violations, which started back in 2022, I think was when he started implementing the new policies. I don't think that we're going to see a whole lot of change with the new administration.
Yeah, I agree with that. I mean, I do think that the the enforcement focus has greatly expanded, particularly within the Commerce Department since 2022. That it is targeting China and Russia. I think the new administration, the cabinet appointees or the cabinet nominees have, in some areas, been a little outside the box. But I think in commerce and in Treasury, quite honestly, and state for that matter, they're much closer to what you would expect from a Republican administration in the past. And so I'm guessing, and it's a wild guess, that the policies would be kind of in line with what you would expect from the Commerce, State, and Treasury in this area. And so I don't think we're going to see a lot of change. I mean, I think that the Biden administration policy of targeting technology in China and Russia is not likely to be, to the extent you can predict these things, it's not likely to change, because they were, more aggressive in enforcement in those areas, and I have a hard time seeing the new administration coming in and being less aggressive in enforcement or shifting the focus. Certainly not shifting the focus away from China.
Yeah, I think the trajectory is going to stay largely the same, especially because of all these other, when you look at everyday living and what is happening there. I think the pressure's on to just keep those controls over technology and tighten them. So I don't think that there's going to be a whole lot of change at all. If anything, maybe more to come.
Yeah, and I do think you'll see more challenges. So I think that because of the administrative cases that came down from the Supreme Court this term, there's certainly avenues to challenge enforcement, even in the national security realm. And the first case that we've seen out of the Fifth Circuit, the one involving OFAC, there may be some other cases, but that's the one that's gotten the most press. That Van Loon case, I mean, there was no difference between how the Fifth Circuit applied Loper Bright to OFAC's decision than how it would have applied to an SEC decision or to any other domestic agency decision. At least that was my read. It was basically like, there's this term, it's property, and it comes from IEPA, and here's what we think it means in this context, and we are the ones who get to decide under Loper Bright. And yeah, OFAC says something, and we'll look at it, but we don't have to defer to it. We don't have to pay any attention to it if we don't want to. And so that and if that's the way courts are going to analyze it, even with OFAC, which is also a national security agency, it may be that in the export control context, even though the administration will kind of proceed similarly to the current administration, if the new one does, the courts may have something to say about kind of how aggressive agencies are going to be able to be going forward with respect to enforcement.
Yeah, and we're seeing more overlaps too into other areas, primarily the financial side, which that's always an interesting development as well, and marry that up with the knowledge. What constitutes knowledge? It's the know or should have known. So I think that circling back to what we were talking about earlier in terms of transactions and building business and working with compliance people, because the willful ignorance, if there is willful ignorance, is not. I mean, it hasn't worked, but it's definitely not going to work going forward. And I think with the increased focus of the government in terms of these when it comes to technology, especially in the countries that are adversarial to U.S. interests, is going to continue to be that focus. And business interests are not going to override that government interest.
Yep, I think that is definitely a principle to live by. Well, we're about an hour in, so I think we probably ought to close this out with some final thoughts. So I'll turn to you first, Johanna, and then Melissa, if you want to chime in with any final thoughts on 2024 and how the ITAR evolved and any of the big changes.
Well, I think it'll be interesting to see what happens in 2025, especially with not just the proposed rules, right? We didn't really get to the space rules, but just seeing export control reform targeting that area in the interest of preserving the competitiveness of the U.S. space industry, which again goes into national security. And seeing how, with the input from industry, how is that going to be rolled out, and will that lead to other changes in the ITAR? Further clarifications, further revisions on that front. Hopefully, modernization is not going to leave us in 2024. that will continue, and then seeing how the implementation of the finalized rules, how that goes, how that shakes out, and what are the practical effects of those changes.
Yeah, totally agree. And I also think that, we didn't have enough time to talk about the space rules, but the new space changes were actually, I thought, kind of a great example of trying to be practical and modern and really streamline the ITAR. And so, hopefully we will not leave that behind in 2024. And I suspect that some members or proximate members of the new administration will have a great interest in modernizing the space rules. So
we can set up a pool, like which will be implemented first, the space rules or defense services. My money is on on space.
Yeah, I think there's a lot of money that's on space coming first. Yeah. Any thoughts, Melissa? Final thoughts in 2024?
No, I think. I do think it'll be interesting to see how quickly some of these pending rules come out and what changes are implemented. A lot of them do have commerce counterparts, which could hold it up or speed it up in some ways. But that's always an interesting exercise, looking for the gaps and overlap between them. You can't really look at the DDTC ones in a closed box and assume if it's not there, you're home free. But I do think these next few months will be a big learning curve for a lot of the companies affected especially by the AUKUS rules, as they're really having to drill down for the first time or first few times on, do we fall under this, or is it the older defense treaties, or not covered because it's excluded technology? And again, that expedited licensing route, one's existed for a while. How will this one actually make a difference? So it will be interesting to see how much things change and how much they stay the same in 2025.
Yeah. On expedited licensing, we have to follow the deadlines whenever practicable. I wish they would apply that to us, right? I mean, yes, you must do this within 30 days as long as it's practicable. If not,
yes.
Otherwise, you can file as soon as you are reasonably able. Would be really nice from the lawyer's side.
And there's no exceptional circumstances that are present.
Yeah,
exactly.
Like it's a Tuesday,
Right. These kind of, optional but preferred deadlines are ones that I much prefer myself.
Yep.
All right. Well, we'll leave it there. And thanks for listening, everyone. And stay export controls compliant.
Yeah. Thanks, and happy 2025.
Yes.
Right.
Yes. Happy New Year to
New Year,
all.
everyone.
Produced by Heartcast Media.